We will kick off today's seminar with a short welcome address by Mr. Edwin Glasgow, Queen's Counsel and Chairman of the SIMC, who is a very well-known figure to many here, and we are very delighted to have Edwin serve as the Chairman of the SIMC Board. Edwin was, together with Mr. George Lim, Senior Counsel, appointed co-chair of the International Commercial Mediation Working Group by the Chief Justice and the Minister of Law last year. It was because of the working group's recommendations that the Singapore International Mediation Institute was launched earlier this afternoon, and SIMC will be launched later this evening. Edwin is an accomplished barrister, an approachable arbitrator. I'm going to embarrass him. And of course, Edwin is also a very outstanding mediator, and no one is more qualified to speak to us today, as well as to welcome everyone. Edwin, please.
Thank you, Eunice. Despite all that, I'm well aware of the fact that the vast majority of you are saying, what on earth is he doing there? And incidentally, what on earth is he doing on the Working Party in the first place? Neither of those questions can I answer, but I am able to make you very, very welcome. It's so nice to see so many friends and some fresh faces as well. Because I am a foreigner, I hope I can be forgiven for breaking with protocol without causing offence. I've attended a lot of conferences in Singapore, and I am actually well aware of the way the thing ought to be done properly, and I apologise for the fact that we don't do it properly. I'm afraid we've broken with protocol, particularly in the introduction phase. I have found that in Singaporean conferences, the introduction of speakers is rather like a cross between a society wedding and children playing pass the parcel. We all know that the society wedding has a hugely uniformed, large man who knows absolutely nobody, but who wears a uniform rather like that splendid outfit that Idi Amin used to wear, the field marshals kept a lot of scrambled egg on, and he has a voice to match. And he booms out unpronounceably the names of people who he has never met and whose names he can't pronounce, just at the moment when the first person but that is saying goodbye to the bride's mother, who is bewilderedly shaking his hand, wondering who he was and wondering whether she is at the right wedding. That's the way we organise our weddings, certainly in England. And the equivalent of the pass the parcel, which I think is small children frantically ripping paper off parcels, passing it on to the next child, trying to make absolutely sure that they are not the one who gets left with the embarrassment of being presented with the equivalent of having to introduce somebody, which is a small plastic toy which costs considerably less than the hundreds of meters of expensive wrapping paper about to then strewn on the floor. But I do know that in Singapore the tradition is that you have the head of the hotel introduces the head of the conference centre, who introduces the leader of the conference, who introduces the person who is about to introduce the people who are about to speak. At that stage everybody is totally lost, but the number of people you've had coming and going is impressive for the hotel, for the conference organisers, but least of all for the person who's actually going to make the speech. We thought we'd do away with about 3 layers of protocol, and I hope I can do that without causing massive offence, leaving in mitigation that I am, of course, a foreigner who doesn't understand enough about local etiquette, and you'll forgive me, provided I buy you a drink later. It does, however, give me the opportunity of more personally thanking Eunice. And I do want to thank Eunice and her team and a number of other people, and I'm sorry that I start the day doing that rather than concluding it, because there are even more important people joining us this evening, and it will become less and less intimate, and I want to say it while it's all fresh in my mind. Institutions like SIMC, like Maxwell Chambers, like the Singapore International Mediation Centre, however brilliantly conceived they are, and of course we all know the SIMC is brilliantly conceived because the Working Party that set it up. It doesn't matter how brilliantly conceived, they can only be as good as, like mediations, the people who operate them. Just as mediations, it doesn't matter who you are or where you are, they are as good or as bad as the mediator who does the job. So are institutions like the 3 that I've mentioned. We are hugely happy and fortunate. Not only could today not have taken place, but the last 18 months of frantic preparation for today could not have taken place without the 3 remarkable ladies. Sad in this sexist world, they are always women who do well, and we have to trail behind them pretending that we aren't jealous. But our chief executive, of course, Geoff Lim, who is outstanding, as we know, manages to run SIAC as well as running SIMC at the same time, and that's an interesting twinning of arbitration and mediation, which we think is incredibly important. Eunice and Francois Duval, and the three of them work together. Without them, we could have done nothing. And we certainly couldn't have managed today without the extent to which, with the huge goodwill, we have disrupted the staff of Maxwell Chambers, who, as always, have made us so welcome. We thought it was much more appropriate that we should come here rather than go to some grand hotel. It'll be uncomfortable, there'll be lots of people crushing in at the end, but we are home showing you what we do and where we do it, and we think that's more important. We couldn't, however, have done it without Gillian and Riz and her team from Maxwell Chambers, or indeed from the support of our loyal friends and neighbours who in any other jurisdiction would have resented our presence, but they have welcomed us warmly, the Singapore International Mediation Centre. So that's the background. What we wanted to do was to give you, and please don't be too afraid, it won't be a serious academic lecture. We wanted to show you a little bit about mediation, and we thought that, so I'll say more about the mediation panel that we have later in the day. I'm just going to talk about two members of the panel, and to get the serious bit over first, John Sturrock and Geoff are, without any question of doubt, two of the finest mediators in the world. They have international reputations second to none. They better have, otherwise they wouldn't be on the SIMC panel, and that's no joke. There is nobody on the SIMC panel who is not of international standing and recognition as a mediator. They are quite special for lots of reasons that you're about to see. One of the reasons why they're special is what we did, being an international organisation, we spread the map on the wall and we took the two jurisdictions most far apart from one another, Scotland at the top left-hand corner and New Zealand at the bottom right, and saw whether we could do it. Now, any organisation that can get a Scotsman and a Kiwi in the same room without bloodshed is doing quite well. It will say quite a lot for mediation, believe me. They do not have a history of long and happy international relations. The Scots, of course, being Scotland, many hundreds of years, couldn't stand the climate or the company, so they've been going abroad, even some of them to England to pinch all the best jobs. Those who couldn't find good jobs in England that went off to Australia found there were too many English criminals that already got there. So they took the next boat on and went on where at least it wasn't a penal colony, and they were made welcome, of course, by the natives who were residing there in New Zealand and set up farming. And there are very few residents of New Zealand, of course, who are not called McGregor or McTavish or something, who sent their Christmas cards home to Scotland. And they got on there perfectly happily and forgot all their Scottish roots until, of course, they started playing rugby, and they fancied themselves no end. The New Zealanders aren't as good at playing rugby, but they do have the advantage of Kiwi, of Samoa, and various other small islands, Fiji, fairly close by, so they can import a quality of player that makes the rest of us. And what they do then is, during their summer season, when they're not beating each other up over here or getting involved in fights in bars, is they come to do exactly the same thing in either Glasgow, Edinburgh, or London, and they play for the clubs. That was all a frankly good idea until Doddy Weir, who played against the great Tian Tuagamala, thought it would be a very good idea to persuade Tuagamala to play for Scotland. And they put him in a kilt and he looked the part. There were one or two people who were slightly quizzical, and he did in fact play for a number of clubs and did have a trial outing for the Scotland second team, at which point they wondered whether they could stretch the rugby union rules far enough to include him in the Scotland team. He appeared as an interview in front of the board, and this is true. He was asked whether or not he had any Scottish blood in his family, and he replied bravely, "Yes, I have it on good authority that my grandfather ate a Scottish missionary." They weren't quite sure that that was the kind of qualification that they had in mind. So as I say, any organisation that can get a Scot and a Kiwi together without, I hope without cannibalism, but short of bloodshed, these two can do it. You're in for a hugely entertaining afternoon. I am grateful to you all for coming. Some of you have travelled enormous distances, I'll be talking about later. No one's travelled further or with more goodwill than these two. I, for one, look forward enormously to being entertained by them. Geoff and John.
It's that time in the mediation, folks, when I'd like to say a few words. First of all, I'll put on my microphone so you can hear what I'm to say. Thank you all for coming here for this mediation today. I realise this is a difficult matter for you all, a It was a feedback for the microphone. Switch that off, and I'll just lean into this one, folks. Can you all hear me at the back of the room? Yeah. So thank you for all for coming to this mediation, and thank you for the honour which you've done to Geoff Sharp and I in appointing us as your co-mediators. It's a real privilege to be here in this room working with such a large and diverse group of parties, given the conflict that you have got. And clearly, as I make these few remarks, which are carefully scripted and somewhat improvised, the tension in the room really has been made clear to us in the words of Edmund Glasgow. Clearly, Edmund is angry and feels the need to vent his frustrations about the situation in which he finds himself as an Englishman in this part of the world. And what we hope is that in this environment, in this mediation environment, which Geoff and I as your co-mediators, is that we can help Edmund and others who've got difficulties and challenges with the matter which presents itself. So, in saying thank you for inviting us to be here as your co-mediators, can I say a little bit about the day and about the role that we are going to play? Our role as mediators today is not to make decisions for you or to tell you what to do, but to work with you as hard as we can to help you work through some of the difficult challenges that you face, perhaps to glean a better understanding and a greater appreciation of different perspectives and different points of view in the mediation process. So we're not here to judge, we're not here to judge you, we're not here to judge this dispute. What I frequently say to groups, people like this, as we convene after our breakfast meeting, is that mediation offers maybe three particular contexts. One is opportunity, one is choice, and one is responsibility. These are three words that you'll find that we will refer to as this mediation unfolds in the course of today. Opportunity for you all to work through the difficulties that you're presented with, to learn a little bit from each other and from us about the way in which this process might work. And choices too, choices to make about how you go forward, and particularly choices at the end of the day about whether you take any of this on board, whether you come to a conclusion based upon the discussions that we've had. And finally, responsibility. Responsibility ultimately in mediation, perhaps different from other processes, is to yourselves, to those whom you represent, to those to whom you're responsible. Responsibility is to make decisions if you wish to do so. Now I appreciate that time is relatively short today. Geoff and I are here for the whole day. We've spoken to many of you in advance, and we know that you're free until the early evening at least, and perhaps later if necessary. We're not in favour of going on till 1 o'clock in the morning, but if we need to, we're happy to do so. Our commitment to you is to give you everything we can in the course of the day to help to make this work. Sometimes it might feel like wading through treacle. Other times it may be, as somebody said to me recently, it may feel like stirring concrete with your eyelashes. What an extraordinary phrase that is. But if it feels like that, bear with us, because we're here to work with you to help you to work this through. Now, I know that Geoff and I, according to Edmund at least, come with some authority, some experience, and I suppose some credibility. And that's important because we're here to guide, to lend you assistance, to be sounding boards, and indeed to ask some tough questions if that's what's required. Every now and again I may put on my metaphorical wig and pretend to be Mr. Justice not very clever, or Lord not very bright, and maybe suggest to you in your rooms privately some of the issues that you may want to think about as you think about the risk that you face. On the other hand, we don't come here with the answers. There's no right or wrong or one way of doing things, and so we make suggestions to you today about how to take this mediation forward. We do so knowing that you may have different points of view. So please do ask questions, make comments, challenge us if you wish, because as mediators, that's our role. We're not here to prescribe, we're here to work with you. After all, it is your process, and you pay us to be here. Well, we think you pay us. You pay us to be here to help you to sort this out. The paradox about this today is that you need to work together. So on this side of the dispute, you need to, for it to work for you, it has to work for those on the other side of the dispute as well. And of course, paradoxically for you to get the outcome that you're looking for, it has to work for these folk as well. That's the paradox of the gain-gain, if you like, or the gain-gain approach to mediation, which we will work with today. And it's not really about how little you give or how much you get, it's what will happen if you don't. If you don't participate, if you don't take part, if you don't agree to work with each other in order to gain something mutually beneficial from the day. That's the benchmark, folks, against which to test whatever outcomes may bear fruit in this mediation. I want to suggest also listening. It may be that because of the situation in which you've got yourselves, it's difficult for you to receive new information. So what I'm going to do is ask you to listen out for things which may be surprising or even challenging, testing the position that you may have taken as you come into this particular dispute. And I'd say that with a particular interest in your culture. One of the things that we have to be very careful about here as we come in from our different cultures, from different parts of the world, is that we don't make assumptions about your particular cultural norms and approaches. Let me say this, just in coming to a mediation in a different country, I often come a day early so that I can learn a little bit about the country and its cultures and its norms and so forth. And yesterday I went to the Malay Cultural Heritage Centre near Arab Street. I did that particularly because, as it happens, my father was born in Negri Sembilan, which is just 100 or 200 miles, as I understand it, up the Malay Peninsula. I've never been to his birthplace back in 1923. But the Malay Cultural Heritage Museum or Centre gave me something of a feel for the Malay culture. And let me just read from a photograph which I took as I was there yesterday. The two phrases which struck me as I looked at the exhibition that was on there. One was Badi Bikara, and I hope I get the pronunciation correct. And the other is just have to find the words. Badi, and that's the wrong one. Just bear with me a second. Badi Bikara, that's it, I found it. That's the trouble with looking at these things on your phone. It's Badi Bahasa. And Badi Bahasa refers to manners. And what I want to do is to build on that idea of manners, which I know is very important in this culture, and to remind you of the need to show respect to each other, to be dignified. It's so easy, isn't it, in a dispute to assume that the other is out to get you, to regard what they say as being malicious or in some way designed to undermine you. But if we can separate the people from the problem, we can follow the Badi Bahasa idea of manners and respect. And the other, and I just hope it will come on my slide here, yes, it's Badi Bikara. And that, it comes from the original Sanskrit meaning, which is wisdom and meeting to discuss in order to find a resolution. And again, just taking that short and perhaps misapplying the Malay culture and language, this is all about meeting together and having discussions in order to reach a resolution. So I'm somewhat comforted, along with you, Geoff, I hope, that the culture in which we find ourselves is one in which we can find mutual satisfaction. We often talk in Scotland about the idea of Jock Tamson's bairns. Jock Tamson's bairns is our idea that in fact we have much more in common than we have which separates us. We're all children, after all, of the same God, with a small g, or the same source, or every man, whatever it might be. And I'm comforted also in having read Joe Lee's Asian book on an Asian perspective of mediation, that much of your cultural norms are very similar to those which Geoff and I have. But let me, ladies and gentlemen, in coming to the end of this particular introduction to the mediation we're about to engage in, just say one or two other things. Do remember, this is hard, I know, that there are several sides to most stories. In reality, you have your perspective, and they have their perspective. And even if you don't agree with what the others think or say, it might be helpful to accept that they see things from their point of view. You might have missed something obvious, you might even have, to use one of the modern psychological terms, reactively devalued what your counterparts have said. In other words, because it is your counterpart or your opponent, you devalue what they say. One of our jobs is to help you to see things differently and to reframe where necessary. I make only one assumption today, and that is that we're all here trying to do our best. We'll do our best, and I assume, and I ask you to assume of others that you will do your best also. So that's really what I wanted to say at this stage, and forgive me for having gone on at some length. I find at this stage in mediation, after we've all met and mingled for breakfast, that it's useful just to have these few words and reflect on what they mean to us. We're going to break shortly and go off to private rooms, because very often it's easier for you to speak frankly and directly to us in the private rooms rather than speaking to each other at this stage in a plenary session. But before doing that, I'm going to have a chat, if I may, with the principals. So could I ask all of you in the room, please, to leave, apart from 3 principals, and we're going to have a short chat here. And there's one further thing I should say. It's about confidentiality. Nothing we say in this mediation is confidential. You can tell everybody in the world everything that you hear, and it will just fine, because it will help us to understand it better.
John, well done. Before we talk about what's going to happen over the next hour, just tell me what we heard. Was that an opening that you would do?
Yeah.
In a real mediation? I mean, I heard breakfast. I heard a paradox, asking people at 9:30 in the morning to work together. That doesn't happen in my world. Tell us about what...
Yeah, well, what this was about is this is an illustration. We've talked about how to start off this event today, folks, and we could have done the usual kind of hello, welcome, thank you very much indeed. But that was a double shift, if you like. One was a genuine introduction to what we're hoping to do today, but it's also a heavily manufactured version of what I do in most mediations. In most mediations in which I am privileged to be instructed, I will have short meetings privately with the parties in their own rooms, and then we will all meet together for breakfast, or its equivalent. Pastries, orange juice, coffee and tea. And the idea of this is it allows all the players to get to know each other, and encourage them to shake hands, to meet, to chat, even those who are protagonists who may not have got on particularly well in the past. And nothing else happens apart from meeting and chatting over a cup of tea, a cup of coffee, and a croissant. And then I do this. And I stand up, and in a much less hackneyed and formulaic way than this, I chat about the mediation day, what's going to happen, and I give them some of the stuff that we often talk about when we're teaching and training in mediation, but we hardly ever use in mediation, such as the cognitive tracks, although I try to find language to make it work. And what I do is try to set a common tone. And then the last piece was, well, again, I try to do as often as I can, and that is to meet the principals on their own, Geoff, privately before we go on. So that's a kind of illustration of a particular approach.
And you'd meet with the principals that early in the process?
Yeah, well, we've met them in the room with their teams. And this will all have been cleared with the lawyers beforehand.
Right.
And we discussed it again, in the private room before we have our breakfast. But it is, after all, the principal's problem. It's their issue for their day. And what I think I'm beginning to discover is the more that we return the decision-making process to the principals, the better it can be, and the more they will be involved from the get-go. So it's a little chat about why we're here. It doesn't always work, it doesn't always happen. But the context, anyway, is set.
And look, we'll come back to that. But should we just
Absolutely.
talk a bit about what we want to do over the next 45 minutes?
Yep.
Folks, nice to see you all. Lovely to see some familiar faces in the audience. What John and I have wanted to do today is set this up as a bit of a fireside chat. So we're going to be sitting down, standing up, but don't take offence if we don't stand up when we talk. You've got a perfect storm. You've got a New Zealand accent and a Scottish accent, so it'll take you another 10 minutes before you get your ear in. So hopefully we'll get the good information then. But what we want to do is develop a conversation with you around the theme of sticking with it. And John and I discussed this at a distance, what we should talk about, and both of us, from bitter experience, have had mediation suffer when clients or lawyers don't stick with the process. And so our theme today is going to be sticking with it. And that may resonate with some of you. I know there are some wonderful mediators in the audience. We've got go-to mediators from Hong Kong, London, Melbourne, Brisbane, or Moscow, all around the world. So I'm hoping that they will chime in as well as everybody else. But the theme will be sticking with it. We've divided it up into 4 or 5 topics. The first one is preparation, so we come back before the mediation. Preparation to maximise the prospect. Are they on? Yeah. The second one is cooperation amongst advisors and experts. That's a particular favourite of mine. I think that is a hugely important aspect of a successful mediation. We'll talk about that, what happens, how we can make that better. Third topic is making the best use of the opening 2 hours. And John, you're going to anchor that.
Yep.
And again, I think that golden hour or two of the mediation is so important. We set the tone. Mediator has a lot to do with that. So do counsel or lawyers. I'm going to use counsel and lawyers interchangeably. I know that in your jurisdiction probably means barristers, doesn't it?
Well, counsel mean barristers and solicitors, so we have the generic term.
Let's try and use lawyers, yeah. Okay.
Yeah.
So making the best use of the opening 2 hours. And then the fourth topic, if we have time, is perseverance and patience. The mediator needs to be front and centre. I always say the mediator needs to turn the lights out. It needs to be the first person there and the last person to leave. And we've got some differences about that.
Yep.
And then the last topic is persistence, even when the mediation has not got to yes. What can lawyers and what can mediators do to bring that back to a successful conclusion? So those are the 4 or 5 topics.
See what's happened to our slide?
No.
In the transmission from Apple to PC, the bullets have got out of sync.
Okay.
And I was completely put off by that. And it's interesting how easily a small thing can unsettle you in a situation like this and in a mediation.
Yes.
So it's interesting, just small things make a difference. Anyway, sorry, Dave.
So, look, I think
Preparation.
I mean, if you can...
Let me just kick off the point.
Yep.
I mean, I found this quotation by Alexander Graham Bell in a slideshow which I put together a while back. Before anything else, preparation is key to success. It seemed to me, though, we need something more culturally relevant, so I found this morning. From Confucius: success depends upon previous preparation, and without such preparation, there is sure to be failure. And I'm a huge believer in the excellence of preparation. I aspire to be, even if I don't achieve this, a world-class performer in what I do. I aspire for others who are involved in mediation that they be world-class performers. I'm privileged in recent years to work a lot with Olympic athletes, coaches and governing bodies, particularly in the lead up to the 2012 London Olympics. And what struck me was the extra length and sometimes very short lengths to which they went in order to achieve success. Micromillimeters, microseconds make the difference for them between gold and 4th place. So at the margins, everything matters. Now the same should apply, it seems to me, to what we do as mediators, but also as representatives of clients, and indeed in helping our clients to be all they can be. So I make a great play of preparation and feel very uncomfortable if people come to mediation underprepared or even unprepared, because I don't think they'll have a world-class performance, nor will they achieve a world-class outcome. So here are some of the thoughts I'm going to work through in conversation with Geoff, and we'll look forward to other conversations. Thinking about what happens in the very first contact and thereafter, the nature and content of communications and aspects of coaching that come into play even at this early stage, how we go about the generation and assimilation, distribution of material in written form. So I've got there joint individual summaries. Now Geoff and I have a discussion about what we call these bits of paper. A lot of folk refer to the contextualization of a party's case as a position paper. I will not ever refer to a piece of paper like that as a position paper, because that simply, for me, reinforces the notion of positions, whereas our approach should be one based on interests. But we can have a discussion about that.
Yes, and I think that's dancing on the head of a pin, really. I mean, everyone in my world calls it position papers, and nothing's taken from it.
And you wonder why you get no mediation there. And then we'll talk about risk analyses and other more, I suppose, sophisticated approaches which advisors can take to preparation. obviously location, venue. I want to come back to culture and the importance of that. Process design, which is itself interesting, because we kind of assume that it's a one-size-fits-all, the 1 day or 2 day classic mediation. In my experience, we can depart from that readily, easily, and flexibly if required. And of course, all of this builds up to how much we get to know about before we can start. And I'll finish off with what I call a preparation question here. So Geoff, let me ask you first of all, how do you get started? With your first call from the lawyer, presumably, and they say, "Hi Geoff, I've got this mediation." What happens?
Normally the first contact is from the lawyer, as you say, and it'll be one lawyer of a two-party dispute or more, and it's normally about dates. So lawyers normally like to establish availability. Often it's, are you around in November, as opposed to, can you do it on the 17th? And that's really the first contact. They will then go away, shore up those dates with all those involved, and come back. And meanwhile, I've just sort of penciled it in my diary. So it's very, very, process.
Yeah. What's the first substantive engagement that you have with them about the substance of the mediation?
Well, look, I'm ashamed to say that I no longer convene pre-mediation telephone conferences, just because of the logistics. So I will. The first substantive contact is really after I've got the papers, and then I'll ring, and it's normally 2 or 3 days before the mediation, and I'll ring the lawyers and just chat through the various bits and bobs. Normally after I've got the case summaries or position papers, and I'll be looking in that contact for what I call mediator intel. So I'm looking for, I know what the case is about, don't bother telling me the third paragraph of the statement of claim. What I'm looking for is the good stuff. And that helps me as a mediator. If I don't get it in that call, I'll normally get it in my private meetings on the day of the mediation.
Can I then talk a little bit about my approach? Can you all hear at the back of the room all right, even though our microphones are not switched on? All right, Danny, can you hear okay? All right. I mean, I'm interested you said that you're ashamed to say that you no longer. We might want to talk a little bit about that. My approach would be, as soon as the date is fixed, following a similar approach to yours, to arrange through my office a conference call, at least if not a meeting. Now, geographically, that can sometimes be easier for me where I am in a small geographical area, but very often not. And I would think always, but then I should never speak universally, but nearly always have a telephone conference call as soon as I can with the lawyers, at least.
I mean, I'd be interested in...
Yeah, so we can open that up?
Yes, because I must say it suited me to move off the default position of having a telephone conference, but the lawyers were certainly resisting that because it became another negotiation over another date, and it was so hard to organise. But I'd be very interested to hear others. Ian Hanger from Brisbane.
While it frequently doesn't happen, and I have the same topic to refer to, I think having an intake pre-mediation conference is important, and not with the lawyers. I like, doesn't always happen, to meet the clients 3 or 4 days before a mediation, because I don't believe most people on the day of the mediation in the first hour are listening. They're too nervous, they're too stressed. If I can have a cup of tea with them 3 or 4 days beforehand, I would like to, and I get to know them, and I get to actually think about the case in the shower that night and say, well, so-and-so is going to be very difficult, and you sort of work out an approach because you know the client.
And Ian, they're from Perth, how do you handle that? They're flying in from Perth, I mean,
well,
all those logistical...
In that case, it can't happen.
No.
I mean, my preference then is to see them at 8 o'clock in the morning and have a chat with them.
Yeah.
But I just think it's for their benefit to see them some days before, so they can go away and think about what you've said.
Yeah.
And you can think about how to handle those people. Some people, and you have to think about the same thing with lawyers as well. Some are very difficult, and some are very easy.
Yeah. I mean, if there are users in the room, it would be very interesting to hear from corporates or individuals who've used mediation, whether they appreciate, some real contact with the mediator prior to the mediation. Very hard to arrange, but... Yeah.
Well,
John.
John.
Oh God. As a user, I think for us, it's actually quite useful to actually talk to the mediator face to face at the earliest possible opportunity, because whilst lawyers are quite useful when you get to mediation, they still have that advocate position and they're trying to sell that as their point of view, whereas I'll be honest, users generally, especially in my area, are looking at more commercial outcome, and you might, as a mediator, you will generally get a better feel for what the actual positions are from the individuals concerned and the concerns they have than you would do necessarily for the lawyers. I think you'll normally find that. So certainly from a user's perspective, it's quite good to talk to the mediator as early as possible.
And I think what comes out of all this, thanks John and thanks Ian, is that there is a diverse way of doing this. There's no one size fits all. But what is really important, I think we all think where it's at all possible, is to engage as early as possible. So whether it's with only the lawyers in a telephone call, either individually or in a conference call format, and it could be either or both. Or as Ian does, meeting with the parties. I mean, I've had one recently where I met with the two principals the evening before the mediation. So they had come in from wherever they were coming in from. I cleared it with the lawyers. I had invited the two of them for dinner, but they didn't want to be in the same room at the same time for understandable reasons. So I had a drink with each of them for an hour sequentially in the day prior to the evening prior to the mediation. It made a huge difference to the way in which the mediation started off the following morning, and that's another spin on a theme. Notice Jane and Arthur, you were shaking your head, I suspect because some of that is just simply physically and logistically impossible, but that's an assumption I'm making. Do you want to add to that before I round off? Yeah.
I was actually telling your wife, John, that in international mediation, which is what today and this centre is about, it is impractical to think that you can actually speak to the parties the day before. They're normally on a flight, but to get them together would be very difficult.
To speak to them on the telephone a day or two beforehand, before they got on the flight.
No, I don't challenge that. It's the actual meeting in person.
It's physical thing.
It's just not possible.
Yeah.
And there may well not be much interest in doing it as well on the part of some of them. If you're looking at individuals or corporates that don't mediate very often, that's one thing. If you're looking at hardened insurers, there may be some in the room who do this reluctantly on a regular basis. Many of them will not be very interested. It's hard enough to get them to come to the mediation these days. To try and talk to them in advance is very hard.
Okay, well, what I would want to do is to challenge some of the norms, but have this. We've got Mike and Liz with their hands up, so let's go with Liz first, because the microphone's nearest to you, and then we'll come to Mike. Elizabeth Birch, yeah.
Just going to say, there's another problem with international commercial mediations, which is that very often we're dealing with a team of people. And there isn't just one player amongst those that's the important person to speak to. And that's another factor which makes it difficult. But I think that meeting the night before, when it's possible, and if I fly somewhere for a mediation, I'll always try and meet the parties separately the night before.
Yeah. So that's a question of timing, isn't it?
It's a question of timing, but also it's logistics in that you can't identify one person to speak to for the purposes. When you've got a large team, there might be the chief executive officer, there might be a financial officer, there might be others as well.
To what extent in your preparation would you then seek to identify who the key players might be? And and not waiting until the day itself, but in your inquiries, however you do it, Elizabeth, what would you do?
That's always a question that I ask the lawyer. So when I have the telephone conversation with the lawyer, the thing I want to know, a lot of things I want to know from the lawyer, but particularly I want to know who's likely to have exercise the authority at the end of the day, Is it more than one person? Who is it? And I want to know what are the personalities. Has a lawyer worked with these people before? Does he know what their personalities are? What's their approach likely to be to mediation? And all of that I can get a sort of objective idea from the lawyer, as long as the lawyer's worked with these people before.
Mike, we asked for Mike level, but yes, sure. Yeah. Well, Geoff, why don't you speak one?
Well, just to follow up what Elizabeth was saying, I often ask for lawyers, who do I need to make a connection with? And it's interesting, it's slightly different from who's the decision maker, but it's who's the sort of the soft authority in the room, and you often get a very surprising answer. It can often be not who you'd expect, but that's the person that I will make eye contact with when sorry.
There's been I'd say a problem with international arbitration. There's been a tendency for proceedings to always kind of follow the same rhythm and the same pace and not be adaptable to the particularities of the disputes or the needs of the parties. I think that's one thing. For example, the ICC recently passed new rules. They have this procedural conference. They sort of force the arbitrators to have this early conference and meeting. And my experience, it helps a little bit to have that dialogue. I think you need to be careful with international mediation in, not falling into that same trap where everything gets done the same way. There needs to be some type of dialogue, especially with international mediation, I would think, to understand how do you want to do this? I mean, and not focus on the, I think you focus on the day. The problems I've had with some international mediations, and I think the ones that were not as well done as they could have been, is that there was too much of an expectation that somehow the day was going to be it, rather than the settlement being the outcome that you wanted. And the earlier that you begin, I think, to kind of figure out how do we do this. One experience I think that helped us immensely was with Christian Dubé, who's a mediator in Frankfurt. He's a fantastic mediator in Europe. Very contentious dispute between an Irish company and an Italian company, so cultural stereotypes, both sides rather emotional. And the way that he scoped out the dispute with lots of conversations in advance was he decided to keep us in the room for the entire day, almost the entire day. So we're in a plenary session, and I don't think he would have done that had there not been a lot of pre-work done, reading about the case and talking to the sides.
That's really helpful, and Mike, just while you're there with your experience, one of the points here is process design, and I think we put that up because we wanted to talk about the flexibility and to challenge perhaps the paradigm of the 1 day or the 2 day. Not to say that it isn't going to be the standard approach for all sorts of logistical, travel and commercial reasons, but picking up on your point, do you think that there is scope for moving away from, or even a need to move away from that 1 or 2 day paradigm? Or are we talking about that remaining as a central component, as it were, but in a continuum in which work has been done beforehand, however that is done, in order that that day or two works really well?
Yeah, I think that it is. There's room to move away from this model of the wonder of the day being where it's all needs to take place. And I'll tell you, I mean, the risk of falling into the old joke about there are two types of people in this world, those who believe that there are two types of people. I think there are two types of mediators. There are those who think that their job is to be there at the mediation to facilitate, and there are others who think that their job is to help the parties reach a settlement, however and whenever that happens. And those mediators cross the boundaries of the day. They just don't, they don't really see the start time and they don't really see the end time.
That's really helpful. Geoff?
Well, I think we on a slide coming up, there's a sort of, this is a process, not an event, which is exactly, I think, what Mike's saying. And I think a lot of us doing this kind of work will spend more time in the pre-mediation stage on Skype, on GoToMeeting, having virtual face-to-face meetings before we land in the country to have meetings with the parties. I think that's just our future, and it's going to be really interesting.
Yeah. Can I just touch on a few more points here, Geoff? We've touched on meetings to move on. I think the very point that you've made about process or event is what bullet point 1 is about. It's getting started with the first contact. For me, mediation starts with the first telephone call, and we're in mediation from that point all onwards, really.
John, I think lawyers need to understand that as well,
right.
That they need to start mediating in the litigation. Once they decide to go to mediation, start, getting your credits.
Well, let's build on that, because the next bullet point is communications and coaching. And I think this is about how we communicate with mediators, how we communicate with the lawyers, whoever they may be, how we communicate with the parties, if that's appropriate and possible. The word coaching comes in because I think you and I have had this conversation. I'm a great believer in the mediator as coach, not as advisor, and certainly not as briefer of what to say, but I think there are themes and experiences we can draw on which allow us to guide the lawyers who might initially be resistant to be world-class performers, to use that theme. And that takes me, Geoff, back into summaries or position papers. I mean, my approach, and I keep saying my approach, so let's an approach is to use the first contact and the first communication with the lawyers, the advisors, to help them to decide what to prepare. So I notice, for example, that you receive your position paper and then we make contact with them. What I'm hinting at here, I think, is that in an initial contact, we can help them to populate the document and even, where possible, to do something jointly so they get into that collaborative mode. What do you think?
Well, I've got to say, in my domestic work, position papers are certainly not the default.
Right.
So we are only discovering position papers as a useful tool domestically. So sometimes you'll just get a shoebox full of papers and go find the issues, Geoff. So I think we're developing a default process, but we're not there yet.
Can we ask then again in the audience, what is your experience insofar as you have been involved in mediation, and what is your perception, even if not, of what would be the most effective way for lawyers who are working in a collaborative process to help their clients to be world-class performers, to maximize the outcome? What would be the most effective way to gather together the basic information, the key information that will help move the thing forward? Is it a shoebox of paper? Is it a position paper? Is it a summary? Is it some joint work together? Or any combination? Yeah. Tim?
John, I'm from Melbourne, Australia.
Well, that's okay, don't worry.
I'll leave that one alone. I was waiting for the New Zealander because the New Zealanders, the mistake they made if they didn't actually get off at Perth or Melbourne, they just kept floating on. We're a little bit in a different position because we've had mediation now for quite some years.
Yeah.
And we're now at the level of sophistication with the courts, where the courts actually make an order for mediation to take place, and actually as part of the order, direct that the plaintiff provide the pleadings to the mediator by a certain date. And there are quite specific directions provided in relation to the material. I was interested in your comments, Geoff, about position papers, because where that certainly has been around for some time is in those matters that are not court annexed. And we've got quite a lot of those and have had for some years. And now in recent times we had legislation that imposed civil obligations upon parties and lawyers to try and resolve matters before instigation of proceedings. So increasingly we're finding more and more mediation before issued.
And Tim, what makes a good case summary or position paper? What do you, as a mediator, find you're looking for? Is it this case involves, or is it something more than that?
Well, one thing it's not is just regurgitating the pleadings. And I'll say that up front. I'm not interested to waste the client's money, quite frankly. It's one that just draws out the issues in salient, almost bullet point. Some of them where you've got no proceedings on foot and they're quite complicated. Some of the best position papers I've seen are ones that actually go right into the detail. Attachments, sometimes they can be experts' attachments. Sometimes we can references to cases as well. But I have to say 9 times out of 10, a lot of the position papers that parties want to offer in the court annexed matters are really useless.
Yeah.
And there's no value.
Mary?
Hi, Mary Walker from Sydney. I think a lot of this discussion is highlighting something that I wanted to raise as well, which are the cultural differences amongst lawyers and their expectations. And I must say I agree with the gentleman behind me that there is no formula. You really do need to work with all of them separately. But with lawyers, I find often, if we're not having a preliminary conference, because in Sydney, years ago, we were having preliminary conferences face-to-face with the parties and the lawyers. And because of the logistics and so forth, it moved away from that to having preliminary conferences over the phone and then no preliminary conferences. Now it's moving back. I leave it to the parties and I say, look, there are at least 25% of the matters in your room, in your filing cabinets, which require preliminary conferences, and you've got to identify them and bring them. And I'm finding they are bringing more to preliminary conferences, but a lot of them, and particularly if they have an international flavour, are over the telephone. When I'm involved in those preliminary conferences, I often ask the lawyers different questions, and there's a presumption that they will look at documents which are, if it is a court ordered mediation, ones which are familiar to lawyers through the court process. So I often ask them two other questions, and I say to them, what information do you feel that you need and that you need to provide to the other party to properly assess this matter for negotiation? We know what's in the pleadings, we know what you're going to put in the position papers, but I need to draw you back. Now I also need you to consider, if there is an agreement at the end of the day, what it is that you see that agreement to be. I don't know that you need to know the answer to that, but I need you to consider that in whatever information you're going to provide, and to talk to us about some of that information now. And I find that even, for example, in basic commercial matters where they're talking about perhaps repayment to banks or whatever it might be, and there might be property involved, nobody's bothered to get a valuation of property and what might be useful for the day. So I think that there are a lot of ways around it, but I certainly don't make a presumption about what the lawyers think that they will want, because culturally, even between Melbourne and Sydney, we have differences, let alone if it's, somewhere in another country.
I think what we're learning from this is that, again, no one size fits all. Flexibility and a lot of thought is required at the preparation stage, and I'm very conscious that as time moves on, we could spend the rest of this session just talking about preparation. That would not necessarily be time misspent. However, we can move on, Geoff. I think what I wanted just to finish off with before we do that, though, is with one tool that I have tended to use over the years, which seems to be helpful. And it's a tool designed to get the parties thinking about what it's really about, if you like, what lies under the surface. And wherever I think it's appropriate, which is certainly not all the time, I will issue to the parties in advance the questionnaire which I'm just about to show you. And I'll ask them either to send it back to me, because it will give me information, or to keep it and bring it to the mediation, or indeed perhaps to complete it at the beginning of the mediation, and then possibly to share the results with each other. All depends on circumstances. Questions like these. What do you really need to achieve out of this day? And if you achieve this, what would that mean for you? What do you need to do to achieve whatever it is, or what do you need to say? What do you need to hear from the other party? I see this being photographed. We will make
John, these are oral questions, or they're...
No, these are on a piece of paper.
Are they?
Questionnaire. What are your main concerns? What do you think the other party's main concerns may be? I'm sorry the setting of these has gone off in the transfer over to PC. Where might misunderstandings have arisen? What do you think the other party really needs out of this? Now that's very much getting into the other party's shoes, preliminary idea or perception of what you think that they might be thinking. And all of these questions as well. Common ground, realistic options. If you're going to work together, what needs to be done? If you're not going to work together, madness and madness. If you can't find a mutually acceptable solution, what will be the consequences if it's not resolved? What do you think will be the consequences for them? Again, applying the madness and madness. Reflecting on these, and this question I'm not so sure about, what might be an outcome which you can live, with which you can live. I think that's actually premature at this stage. And therefore I will often say, answer the questions that are helpful amongst these questions. But just think about that. I don't want to set this up too highly, but that will often go out to the lawyers who will circulate it to their clients, who will discuss it with their clients, fill it in, send it back to me in advance, or, and I've done this recently in a very complex multi-party situation, have the principals and the lawyers sit down in a room and go through each question sequentially, turn about, and tell each other what they've written. And also, a spin on this, what do you think the other guy wrote in his answer?
And John, they don't, these are sophisticated business people, they don't feel this is a bit like playing in a sandpit. What
do you think?
Well, yeah, I do. I think I might feel I was manipulated.
Why?
Well, just this, just the structure would worry me. I'd wonder what where this is going to, as a party.
Okay, Geoff, you're a party, all right?
Yep.
So I said, Geoff, you kindly filled in this preparation questionnaire.
With some reservations.
Understand that, and many people do. And it's designed to help me to help you to achieve that outcome.
Yeah.
What I'd like you to do is to come and sit with Joe from the other party, with me and your advisors, and we're going to go through these questions.
Well, if I'd known that, John, I probably wouldn't have given some of those answers, which are, to be fair, pretty honest.
And when I sent it to you, I said it was confidential.
Correct.
So what I'm not going to ask you to do is to share with Joe anything with which you're uncomfortable. All right? However, I want you to think about it.
Well, I tell you what, I would like to know some of Joe's answers to a couple of those. So that, to that extent, I'm getting something for troubles.
Yeah, and what I think you might find is that Joe would quite like to know what you think about a couple of these also.
Yes, I can see that.
Yeah. And without, because I can't compel you to do anything in this mediation.
No, and you're not.
No, without doing that, I'm going to say to you, think about it. Think about it. Why is it that you would like to hear from Joe? What he's written to a couple of these questions.
John, I'm not sure if this answers the question. Some of those I feel are really early. Some of those feel like 4 o'clock questions to me, and it's only 10 o'clock. So that's...
Got you. And do you remember when we came in, you said, I'm not staying till 4 o'clock, that's all done before.
Yeah, that's all changed.
It's all changed. So all I would do, listen, I'm going to leave you with Bert, your lawyer, and think about this, and I want you to ask yourself, what do you think Joe might get helped by hearing from you?
Yeah.
All right, we may not do all these answers, but the idea is to give us a bit of structure, a bit of framework, to get you and Joe to think about things.
Fair enough.
All right?
Sorry, John, to what extent do you actually find the actual client, to what extent do you find the user actually fills this out, and to what extent do you think the lawyers fill this out?
Because
I have no feeling that you will find very sanitised versions of this coming back to you, having gone through the lawyers.
Well, let's accept.
Even if it stays confidential, John?
Even if it stays confidential,
let's accept,
it will be sanitised.
Let's accept that that's even if that's the norm, it's better than nothing.
Yeah.
It's something to work with. I would hope, and certainly my experience is that some lawyers will pass this to their clients and will work with their clients to possibly. It depends upon the sophistication of the lawyers and their understanding and understanding all of the commitment to the mediation process. And we're talking about international commercial mediation, something which is in the foothill, virgin territory, and trying to help people to make better use of it. So we're being provocative, we're throwing these out. I don't use this all the time. No. Of course I don't. I'm not naive. But if I get something from this, which I would not otherwise have got, it's a little pearl, John, which might allow me to ask a question that might make all the difference. But there's no harm than that.
John, I was thinking something very similar there. I think these are all really good questions. I wouldn't give them notice of them, because I think that once they've been sent the questionnaire, and I agree the lawyers may interfere with the answers, then they know what the questions are. These are questions that I think you pose to the client in front of his lawyer, but you address the client to it, and the lawyer is cut out of the picture, because some honest answers to these questions, 3 o'clock in the afternoon, you might get one at that stage. But to give them notice in advance when they've committed themselves to a litigious stance in one of these answers, you can never be able to use it. That would be my concern.
Well, and therefore maybe you have to decide and be discerning about when and how you use it. And I'm content on that basis. I know it works in advance, and for the same reason that you have given, they may be more appropriately used orally later on. So we leave it really as this is choice, isn't it? This is a marketplace of ideas. We need to move on, Geoff.
Sure.
Can we move on to this?
Yeah. Let's talk about cooperation between lawyers, between advisors. I might focus on lawyers, but I know that you want to talk about, and Michelle Calpitos has views about this, cooperation between experts, which is as important. I get asked 2 questions from lawyers when I meet them in the street before a mediation. What should we be doing to prepare, and secondly, what should our posture be? And I think lawyers often are confused about that, especially litigation lawyers. I remember when I was still in practice and flitting between the court being an advocate at mediation and a mediator, and that was in the very early days. And I can remember doing my head in. I could not seem to make the switch. So the lawyers often ask, what should my posture be? I think some of them think it should be nicey nice, which I think is completely wrong. Others think they should be a sort of bodyguard and run interference between the client and me and the client and the opposite number. So I think it is a perplexing problem for lawyers who, are not always in mediation, but are experiencing the mediation room now more than the courtroom.
So what are some of the antidotes to these concerns that you as a mediator can deploy to help the lawyers?
Well, I think transparency is a big one. Once the lawyers know that you as a mediator don't have a hidden agenda, I think the trust develops. And certainly I love working with lawyers who I've worked with before, because there is a development of trust and cooperation, and they understand that you're safe with it, you can be trusted with information, and you don't have a hidden agenda, you're not trying to get anywhere. And I think that really means they become a strategic partner. And I think there's a lot of talk in mediation communities about lawyers and mediation, and some of our academics, lawyers and mediation. The government is setting up in New Zealand mediation schemes where lawyers aren't allowed in. Lawyers for a mediator, a working, jobbing mediator, are absolutely essential.
So if you've got a particularly difficult lawyer in a mediation, or even before a mediation, and you're having a conversation with that difficult lawyer, what are the kind of things that you would say to encourage him or her to become more, I suppose, cooperative, more amenable and effective in the mediation process? Why don't I play that lawyer and you could be the mediator?
Yes, all right.
Do you mind if I just throw you in like that, Geoff?
No, that's fine.
Improvised role play. This is just, no, I don't get it at all, Geoff. I mean, all this nonsense about collaboration and cooperation.
Yeah,
I mean, you asked me to prepare, position paper, I'll set out what I think.
Yeah, look, I think, I'm not asking you to take a back seat. I'm not asking you to, not advocate for your client, but I do think that, it's more how you say something rather than what you say. So say what you like, but I think some of the wording you're using is just going to poison the well that you're going to have to drink from.
Yeah, but
mediation.
Edmund Glasgow, for his client, used all sorts of inflammatory language.
Yeah.
And quite often he's abusive towards New Zealand and Scotland. Why should I not be allowed to use the same language back to him?
Well, I think you have a choice. I mean, take the high road or not, but your choice. I would say, and this is easy for me to say, I know, but eye on the prize. Where do you want to get to? And work out how you're going to get there. If you want to respond in kind, absolutely. I'm not sitting here saying don't, but I would. Part of my role is to coach, and part of some of the wording that you're using is getting some airtime in the other camp. No doubt about that.
But I haven't done much of these before, and it feels as though I'm giving in to this guy. Big posh English QC.
Yeah. Well, look.
Sorry, I just did chip off my shoulder. Yeah.
Well, I think we could go on.
Yeah, absolutely.
I think that the point that I'd like to make is that lawyers who cooperate with the mediator and each other, can really pull a mediation along. I think when you get two clients who are not working well together, that's one thing.
Yeah.
But when you get lawyers and the mediator who are not working well, that can sink.
So you mentioned here fertile areas of cooperation, pre-mediation, position paper, at the table. Let's leave drafting for just now.
Yeah.
You can just pick one of these, Geoff, and just expand upon how at one of these or in one of these stages or bullets a difference can be made.
Well, I was asking Tim what makes a good position paper before. I think that a well-written position paper is a a wonderful tool for a lawyer. My own sense is that it should be short, 2 to 4 pages. It should be helicopter view, and it should, I think, and I'm not sure how this translates, but I think it should address the peace and not the war.
Yeah.
So it shouldn't, be all about this case involved, the issues are this. It should be, in some ways, it should be focused on the commercial imperatives trumping the legal rights. And I think that's hard to do as a litigation lawyer, but I think, a client, a business person absolutely can do that. And if they don't do it in the position paper, they'll certainly do it at the mediation. And I think that's the secret. The commercial can come forward, and the legal.
Well, I think that's a really important point. I might just open this up for a quick conversation. One of the greatest areas for learning for me, if that's the correct way of putting it, in the last few years, having been a lawyer, I no longer call myself a lawyer, but not in practice anymore, is the expansion of the matrix, if you like, problem solving from just legal rights and remedies and the facts, which are often all that appear in these position papers.
And which happen.
Yeah, so the multifaceted nature of commercial problem solving, reputation, publicity, risk, management time, opportunity cost, actual cost, litigation expenses and costs and so forth, right through to stress, morale, turnover of staff, contracts lost and so forth and so on. And as we sit and chat here, it seems to me that these are all relevant matter for summaries, or if not summaries, certainly for full discussion on the day. And often I suspect these come in at the side and we've got marginalised. What do you think?
Well, I think some of those can be in the position paper. Some of them may well be sensitive and,
of course,
and either for the mediator's eyes only. I sometimes, not often, sometimes get 2 papers. One open paper that's exchanged, and the second paper is for me only, and it's got what I refer to as the mediator intel. Look, we've had a difficult birth on this. My opposite number is difficult. I'm being difficult. The client is X or Y. That's tremendously useful. If we're talking about position papers, I got this a few years ago, and I kept a copy of it. This is a position paper that's headed up in bold type and capitals. Nothing else. It's headed up. The reasons why ACME's claims are rubbish. And that was the start of a position paper that effectively sunk the mediation before we even started. So they are important tools. I think lawyers can give wonderful, subtle signals through them if they choose to.
Yeah. I'm very conscious that we want to move on to a couple more topics and time is running on. Can I assume, that because we started about 15 minutes later, that we might just have a little bit more time after point of order? 5? 4 minutes, 4 o'clock. 4 o'clock, that's lovely. Thank you so much for that. Okay, this is all about cooperation amongst advisors and experts. And what we're, I think, focusing on is the enormous benefits that will come if we as mediators and service providers can encourage and help the advisors of the various parties to cooperate as much as possible. So let me just ask for one comment before we move to the next session on anything or section, anything that we've said, particularly any challenges to anything we've said. I'm going to leave that.
Are you going to leave that?
Yeah. Yes.
John, I'll take issue with the first point. Ill feeling between clients will often influence counsel. My experience is the other way around. No offence, Edwin or anyone else. But it does. And in fact, I like to link it with the cooperation at the table because so that I'm not bagging barristers all the time, I will tell a story that's in favour of a silk. Came from Sydney or mediation, and at the joint session he conceded all the problems they had. He was for the plaintiff, conceded the problems, the defendants were left with nothing to say, and as a consequence the mediation settled very, very quickly. So he took the cooperative approach, but I have had 9 times, in fact my wife will tell you when I prepare the night before and I read the material, I'll invariably look for who's done the pleadings, who's signed off on the pleadings and who's the solicitor, and I'll tell you how the mediation will run.
Not that you make any prejudgments.
Not at all, John. Not at all. Yes, Geoff.
Well, the other way a lawyer can present, you know, in addition to being a bodyguard, is a hired gun. And I think that first bullet point is referencing that. I often see a lawyer who sees him or herself as a hired gun and absolutely reflects the client's posture to the other side. And I think good lawyers don't. That would be my first comment. But some lawyers will just simply take that as almost a mirror. And it makes it very difficult.
Okay, let's move on in the interest of expedition.
Well, to the opening 2 hours, because I think that's a really interesting.
Well, it's interesting. So what we're going to talk about here is whether and to what extent the mediator meets with parties privately and who that might be. We've talked a little bit about breakfast, meeting with principals, we talked about earlier on, managing a presentation of information. I think this is an intriguing part of this. To what extent we coach, given that the objective overall is to achieve understanding, build confidence in the process and get the ball rolling. So, Geoff, thoughts about the first 2 hours? What are your first 2 hours in a mediation about? What do you do?
Well, I'm trying to set a tone, and I'm trying to what I in my own mind see as sort of depositing credits in the bank, because I know I'm going to withdraw in the afternoon. And so I'm like all of us, I'm sure, much more active in the morning than I am in the afternoon a lot of the time. But it's a cliche, but I'm trying to build trust in whatever way I can.
So if I was to observe a mediation conducted by Geoff Sharp of the normal sort, what would be the structure that you would follow in that first 2 hours in terms of meetings with whoever you meet with?
If we're talking about a one-day mediation,
that.
let's just assume that change. I'll meet with each group or affinity group, depending on how many parties. I'll meet with them privately before we convene in joint. So the first thing will be to meet and greet and meet them privately. And a two-party mediation, that may take, half an hour, maybe a bit less.
Is that half an hour each?
No, normally I would try and keep it to a quarter of an hour each, but it's really just to start that conversation. Then we would convene, and again, I'd be interested in, Michelle, you might have a comment about this in terms of the London practice, but I will normally be in joint session doing the heavy lifting until lunchtime from there on. So we might get into joint session, say around 10, and we'll stay there until lunchtime, and we'll break for a loose stop or lunch. And I find that's the engine room of the mediation, and that's where that's where all the hard credits go in that we can withdraw on later on. Yeah.
Let me just, before opening,
sorry, Michelle, you come in.
Up the floor. My approach would be like yours, to start off with private meetings with the clients and actually arrange for them to come at staggered start times, so that I can start, say, 20 minutes or half an hour with party A, 20 minutes, half an hour with party B, and 20 minutes, half an hour with party C. And if necessary, I will take the half an hour, because this is important in terms of building engagement, finding out who's who the key players, decision makers are, what the dynamics are, and a little bit about the sense of what they're looking for.
And John, I think those early private meetings allow the lawyers a role as well.
Yeah,
they're often very generous with me in terms of, saying, here's have the direct conversation, but it allows them to start work as well.
Well, they're part of the whole process.
Yeah.
Then what I would do is have this, and this is conventional, not always practice. I have this breakfast, or this gathering, breaking bread together for 10 minutes, 15 minutes, and I will then have my spiel, an example which I gave in manipulated form at the start.
See, I find that breakfast intriguing. I just don't.
It's good for you.
Who pays for it? Who pays for it, John? Who pays for it?
Who pays for it?
Yeah.
Parties are happy. It's not expensive. We have a couple of bottles of juice and a few croissants.
We have fights about the cost of the room.
Yeah, we're talking about multi-million-pound cases sometimes. Even if it's £10,000, it tends to be a small part of the overall cost. Anyway, it's interesting though. There might be a battleground over that, and I find now that I'm accustomed to doing so often, and this is more, I suppose, domestically, but I also have done it internationally, that people just take it as read. Anyway, be that as it may, and then I would, wherever possible, meet with the principals, having set that up in the initial meeting, I would then possibly also meet separately with the lawyers just to touch base with them and to manage the process of what I call a management meeting. And then my plenary session, I very rarely now have the classic of one side setting out the position and the other side setting out the position. I just think that can tend to be negative, regressive, and unnecessary if the papers that are prepared in advance are well done. I will tend to have one party, usually the claiming party in the broadest sense, set out their stall in the way that they want to, and it usually would be the client, perhaps with the lawyer and even the expert supplementing, depends upon the circumstances, and then I'll adjourn. After perhaps a few questions from the other party, and I'll say to the other party, this is all set up, but give you time to go away and think about what you've heard, distill it, digest it, and think about what you're going to say, not in a tit-for-tat response, but what you want to say to build on this. And a half an hour or 45 minutes might pass, and then they come in and they set things out. And that is a twofold advantage of making it seem as though they have listened to and are responding to what is being said by the notional claiming party. And secondly, it's a much more creative and constructive approach because it cuts out this kind of yeah, boom, yes, no, right, wrong approach. And by 11:30 or so, there's some really rich material out on the table with all sorts of possibilities there for further sessions. So it's just a different way of doing it, Geoff. What I'm very keen to do is to break the mold of the traditional fixed approach to plenary sessions.
Yeah. Can we take a bit of a poll? Do people still see the value in joint sessions? Because I know the Americans California anyway is a corpus only model, which I find I'll retire if it comes my way. But what do people think about joint sessions? Are they dangerous as lawyers? Are they dangerous? Are they bear pits? Are they unscripted? Ian, hang it.
I tend to go along with what you were saying before. I think the longer you keep people in a joint session, the more chance you have of success.
I absolutely agree.
Together. Yeah. And the reason being that, and lawyers are always wanting to stop the joint session. Heard what you've got to say, let's go out and do a deal. And what you learn in private session, you say, well, that's terribly important. Why didn't you say it in there? And the mediator, if he starts carrying messages, is going to misrepresent things by accident. So I think the longer you stay in that session, the better.
Michelle?
I agree with you. The longer the open session can last, the better. I do a lot of training for lawyers as advocates in mediation. And lawyers who tell me they don't want an open session are missing an enormous opportunity. Because as they point out to them, it's the only time that a lawyer is allowed to speak directly to the other side's client. And my great philosophy is that if you manage the open session properly, a clever lawyer who's prepared properly and knows what mediation is about, he sets the agenda for the discussion in the other side's room once we go into corpus. And that's the secret. When I go after an open session, go into the room, and they're not talking about their own case, they're talking about the other side's case. To my mind, that is a successful opening session by the other side's lawyer. And I think lawyers too often don't realize the benefits of really preparing well for mediation. And I agree with you, it's not a sort of yahoo and this is my case, that's your case. It's just making concessions and setting the agenda for the discussion for the rest of the day.
And Michelle, it's wonderful to watch a skillful lawyer in a joint session making a connection with the client on the other side. Yep. And that's a frightening prospect for the lawyer on the other side. That suddenly there is some spark between the lawyer and the client, the opposite client. I think it's wonderful.
And before going to just behind, Michelle, to what extent would you consciously coach the lawyer and perhaps the client, not again in what to say, but how to go about it so that they do make more effective use? How do we cut and dice the plenary session? We're all saying the same thing. It's how you make the best use of it.
Well, as Geoff does, I see each side beforehand. Usually, it depends on the case, it depends on the clients, it depends on what I know the lawyers or the clients. I make sure that session is a thorough session, and that's where I tease out what they really want to say to the other side. Now, often I'm asked, well, Michelle, what's your view? Do you think if we said this would be a good idea or a bad idea? Well, again, depending on the circumstances, I would answer the question the best way I can. So it's not actually coaching, but people forget that the best lawyers speak to the mediator before they even get to the mediation day. And I try and persuade lawyers to find out three things from their clients. First, it's rather like your list, but I don't have the list out. What their client actually must have out of a settlement, what they can't possibly have out of a settlement, and what they would like to have out of a settlement. Now, if each side does that, and then they tell me, I'm able to help them much better to make the open session more productive, and as I say, set the agenda for the other side's discussion once we go into caucus.
Excellent. Can I ask to pass the microphone to the gentleman just behind?
And then George. And then George.
George.
Yeah, in my view, the joint session is extremely important for three other reasons. One is that, firstly, it allows the parties to vent their feelings, because that's just as important part of mediation as resolving the case. Without a joint session, they can't properly vent. The second reason is that it allows both parties to hear each other's cases, things that perhaps they were not advised by their lawyers. And the third reason is that it allows them to break the ice. Even if they don't like what they're hearing, that itself is a form of communication. Without that, if it's too sanitized, it's harder to reach a resolution.
Good. Something occurred to me that I may have given the wrong impression. All I'm suggesting is the possibility of breaking up the joint session and having a bit of an intermission, if you like, between the two and enhancing it. But then, of course, that's a matter of choice and circumstance as well. George.
Yeah.
Can I just say to you folks that George may or may not say this, but George and I trained as mediators in Edinburgh together in 1996. Extraordinary.
And we're meeting again for the first time after 18 years.
And George hasn't changed a bit. He's not, in fact, anything, he looks younger now.
Yeah,
Notice the lack of
you didn't tell me you were
reciprocity.
married then. Where's Jonah? Yeah, you didn't tell me you were married then. Okay, I found it increasingly important to hear the parties. I know we say that theoretically, but I did a medical negligence case on Monday. And it was just the patient explaining what he went through, and the doctor hearing that. And not only that, his wife was with him, and his wife explained what she went through as well. And that was so powerful and so important. It came out raw. You know, it was not structured, but for me, I tell them it's important for you to say what's in your heart. Because we find it increasingly so that parties don't talk to each other for 2 years, they talk to the lawyers, and this is the first opportunity that they have where they hear each other and they begin that communication. So for me, from the last 10, 20 mediations, I find this important to let the parties speak right at the beginning.
Yeah, great. Good stuff. Thank you very much, Steve. Elizabeth?
So I was just going to say, I'm not sure about, just from I think this is a matter of personal style, and it's also a question of the parties and the personalities you have there. There are times when it seems appropriate to break a joint session, let the parties take a breather and come back again. But equally, for me, when personalities are right, the flow of a joint session can be absolutely magic. And indeed, I mean, there are occasions where seldom I agree, but there are occasions when you can even settle the case in a joint session, because if it's going well and the magic is there, you know, the flow goes, you clear a lot of misunderstandings, parties start to make connections, drop the suspicions that they've had with the other parties. And I would be, if that's flowing well, I would be very reluctant to break that. And that's my ideal joint session. I don't always get it, but my ideal joint session is one which really flows.
And Elizabeth, if the joint session all goes wrong, strategies you just break,
yes,
or let it go wrong and then let it build.
Well, of course, as a mediator, you don't always have complete control of that. I mean, I'm on my mettle in joint sessions, saying to myself at every moment, is this a moment when I should be breaking this? But of course, sometimes you miss that moment, and it has all fallen on the ground, and then you have to build it back up. So you have to work with what you've got.
Yeah.
But more often than not, it seems to me that given reasonable personalities, an enormous amount can be achieved by the good flow of a joint session.
And what's interesting, I think, about all of this is, as ever, that, as you say yourself, much of this is down to individual style. Nothing is fixed. One of the points today is to throw out some ideas, sometimes provocatively, and appreciate the richness of the diversity of approaches and, of course, the reality that in most situations, circumstances will be variable, and therefore we have to adapt, and that's the great joy of the discussion. Geoff?
And John, even in coaching is controversial in some jurisdictions. I mean, I have a lot of discussions with lawyers about coaching. They say, you do what? And, you know, some people don't see that as the legitimate role of a mediator, whereas I think as we get on in this profession, in this field, it's becoming more of a role than ever before.
And it depends what we mean by coaching. And as Michelle was saying, how we do it.
Yeah.
Let's finish off, Geoff, with this. The whole thing is about sticking at it, even to the point where all seems lost, an extra bit, the extra margin can make all the difference. So I'm going to ask you just to pick a couple of points from here, and,
yes.
and we need to wrap up in a couple of minutes.
Well, I mentioned inoculation there, and that's my sort of current buzzword. I think inoculating is a wonderful tool to prep lawyers, to prep parties for the long haul. And so often I do mention to parties, look, there's going to be a 3 o'clock, you know, it's darkest before the dawn, all that kind of stuff. Just be prepared for it. Stick with me, and I often put it on me, hang in there with me. We will get through this, even if you don't think it's going anywhere, you know, 80-20, all that kind of stuff. And I think
80-20, what does that mean, Geoff? You keep saying 80-20, we're going to get there. I mean, look, it's 4 o'clock.
I know, and look, John, all I can say is we've done our 80, and we're about to get to the 20.
Can you guarantee that?
Yeah, and it'll happen quite fast, so I need you to just hang on there with your fingertips, and you might have to make some decisions under some pressure, but that's what you've come for. And you've done all the good work. You know, we have a number of agreements in terms of what happened, why it happened. We think we know where this should end up, just in terms of conceptually. So here we come. As my friend Geoff Privis in California says, buckle up, we're coming into land.
And with that, the key thing is to stick it in. I don't know about you, but think of the number of mediations in which at 6:15 or actually 4:29 is the usual time it all gets really tough. You know, people say this is not going to work, and you might think to yourself, gosh, I have no idea how this is going to work. But sticking at it, working at it, and keeping the pressure on it, Geoff, I suppose, as you just did with me there, because most people want to resolve, don't they?
Well, I think it is legitimate for mediators to push and prod to an extent.
Yeah.
But I think it's very dangerous, and we all know the feeling that, you know, we're the only sponsor for resolution in the room, everybody else is disengaged. I think it's a very dangerous place for a mediator to be the only one leading the charge at 4 o'clock in the afternoon. And unless you've got people with you, hanging there with you, who are saying, yep, I can see us doing this, then I think it's very dangerous.
So the key then is not to be in that dangerous place and to draw away, which is the whole point of the exercise today, is to think about the means by which, from the get-go, from the first call, we engage people sufficiently, whoever they are, whatever role they have, so that when push comes to shove at 4 o'clock, 4:29 or 6:15, they're with us.
Now, I think our parties are getting fidgety.
They are.
So we should go into private session.
I think we should. Now, we did have a slide here.
We did.
And one question was, do you do all your follow-up within the same price, Geoff?
Yes, I have a very simple pricing structure. I charge a fee for everything, no matter how far I fly, no matter how long I go on the day or the...
This is not a marketing opportunity. Yeah, but you include everything. Is it something that doesn't work? And so you follow up, follow through?
And if necessary, meet again.
Yeah. I think the key thing here is the follow through and the follow up. I think most mediators here will do this because they don't all resolve or settle on the day. And the question is, what can you continue to do as mediators interested in the parties and their futures and resolution, which keeps them on side and gives them the best chance of finding that settlement at some point.
And look, I don't think they want you to give up. If they do, they'll tell you to, clear off. But until they do, I'm ringing them every week, 2 weeks, whatever makes sense.
Last bullet point here is end well. And there are lots of things one could say. I remember one mediation where we thought we got to the deal, and somebody said, let's get some wine in. And I was still quite a naive, inexperienced mediator, so I went out to the local wine shop, got a bottle of red and a bottle of white, brought it back in. This was about 7:15, and all it required was for the lawyers to work out the draft of the settlement agreement. It was a complicated IP matter. At 11:15, the wine was all consumed. The only people who had consumed it were the lawyers. They were incapable of typing or writing the words, far less formulating the agreement. So we had to adjourn and meet again for another day, because the whole thing unwound in the meantime to never have booze, so you're absolutely sure it's signed and sealed. And it's really important to thank people. So before we finally conclude, can I just say, first of all, thank you to all of you for your engagement. Acknowledge your listening and involvement, say how much we appreciate it, and invite you to think about this. To what extent should mediators be helping folks to learn from the instant matter, the instant case, for the future? Because, as Confucius said, he who learns but does not think is lost. He who thinks but does not learn is in great danger. So for you folks, without spending time on this, what we would invite you to do at some quiet moments today or tomorrow is ask yourself, from all that we've discussed in the last hour and 20, what will make a difference? What one thing would you do differently tomorrow and why? How can you make better use of mediation, perhaps in the light of what we've said, and write down 3 points, because that's always a way to take away, think and learn from a session. But meantime, we're going to say, Geoff, thank you all very much indeed.